So during direct examination, you kept repeating how you stated that Mr. Hawkins would say you would pay for things, correct?
Yes.
However, isn't it true that pursuant to the divorce decree and those messages in which you presented earlier, that you were actually ordered to pay Mr. Hawkins a monetary amount, correct?
I was referring that he'll say you'll pay for things, meaning there will be a consequence to you.
Oh,
You will be
Miss
harmed
Stewart,
by his
I'm not
actions.
asking you, if you don't mind, I'm not asking for your interpretations of his statements. I'm just simply stating the facts. You
And
would agree with
I'm
me that
clarifying
these
my
statements-
statement.
Hold on. First, you answer yes or no. Then you may clarify your answer. And she won't interrupt. You are entitled to clarify it, but start out, listen to her question, answer the specific question, and then explain it if you need to.
Okay.
So I'll just start over just so we can start fresh. So you would agree with me that you stated that Mr. Hawkins said repeatedly that you would pay for things, correct?
Correct.
And irrespective of your interpretation of what he meant, isn't it a fact that in the divorce decree, you were ordered to pay Mr. Hawkins a monetary amount?
Yes. I paid him a monetary amount. He sold his custody rights away. I interpret when he says you will pay for things, meaning you will, as a threat, that you will be harmed by my actions if you do not comply with what I want you to do. He is not talking about money, in my opinion.
Let's actually talk about how you interpret these words in which you claim in which he's told to you. Now, you said on direct examination that you take it as it is him threatening you physically, correct?
Correct.
However, these are just verbal statements made to you, correct?
By someone who carries a gun at all times. Yes, correct.
Yes or no first, and then you clarify, okay?
Okay. Sorry, Your Honor. Yes, by someone who carries a gun at all times.
But he has never threatened you physically, correct?
Yes, he has.
He has threatened you with his gun?
No, he has not.
His gun? Has he ever threatened?
Give her time to answer. I can't hear both of you at the same time. Okay, I know there's a delay, so take a little extra time, please.
Yes, Your Honor. Mr. Hawkins has never threatened you with his gun, correct?
Correct.
He has never shot at you?
Correct.
He has never hit you with his gun?
Correct.
He has never hit your son with his gun?
Correct.
He has never threatened your son with his guns?
I can't speak to what happens when I'm not there.
But to the best of your knowledge, in your presence, Mr. Hawkins has never threatened your son with his gun, correct?
Not in my presence.
And so even though you take his statements as him threatening you physically, Mr. Hawkins has never threatened you physically with his gun that you claim he has on his persons at all times.
Not with his gun, that is correct.
All right, Ms. Robinson, I'm just going to request that you not repeat questions. I'm pretty good at one time. I got it.
Yes,
Save it for argument.
Yes, Your Honor. I'm ready to. Now, I also want to talk about a couple other circumstances. One being the doctor's appointment that you testified about on direct examination. Now, just to be clear for the court, at no point of time at the doctor's appointment did Mr. Hawkins threaten you.
Which doctor's appointment are you referring to?
On direct examination, you spoke about a doctor's appointment in which the two of you went to.
There have been a couple.
Was that on January 12th?
Correct. That is the one that you testified about on direct examination.
So you're referring to the appointments on the 13th of January then?
Yes, Your Honor. Yes. That you had testified about direct examination, that particular doctor's appointment.
that particular doctor's appointment, the one that was canceled because of his behavior. Yes,
At no point of time. Oh, I'm sorry. Go ahead.
In the presence of the security officers who were present when we were in the same room, he did not threaten me in the presence of security. That is correct.
And while you were there at that doctor's appointment on January 13th, you did not call the police against Mr. Hawkins for any type of violent behavior against you, correct?
Correct. However, I had called them earlier and they had told me it was a civil matter and they could not do anything or help me. Therefore, I did not feel that they would be helpful if I called them again.
Well, let's actually talk about that civil matter. Now, on direct examination and as well as your petition, you had mentioned how Mr. Hawkins did not inform you about the whereabouts of your son on January 13th, correct?
Correct.
And that was in violation of the parenting plan, correct?
In the law, as I understand it, yes.
Correct. And that parenting plan was issued from your divorce decree.
That is correct.
Correct. And you also mentioned about Mr. Hawkins supposed to retrieve the gun safe from your home, correct?
Correct.
And that gun safe provision was also in the settlement agreement for your divorce.
I believe so. I would have to review the exact wording of the decree.
And you also, I'm sorry, go ahead, Ms. Shockley.
I was just going to clarify that it is, I'm not sure whether it's in the parenting plan or the settlement agreement.
And you would also agree with me that on direct examination, you stated that Mr. Hawkins did not comply with the gun provision in regards to providing you with the serial numbers and inventories for his firearms, correct?
Correct. He has not complied with any court order to date.
And those are all the court orders from your divorce, just so we're clear.
He has not complied with the TPO, which is not from the divorce. So no, not just the divorce.
Asking about these particular circumstances, in regards to the guns, in regards to the gun safe, and in regards to the parenting time. All three of those, you would agree with me, are in violation of the divorce decree, correct?
Yes, and the guns are also in violation of the current TPO.
I'm talking about the inventory, Ms. Stewart, the inventory in which the divorce decree was instructed him to provide that information to you. That was not in this protective order, correct?
In the protective order, he was ordered to turn the guns over to law enforcement.
Ms. Stewart, I'm asking about you testifying on direct examination, how you took issue with Mr. Hawkins not providing you with an inventory of the firearms. And that is in violation of the documents from your divorce, correct?
Ms. Robinson,
Correct.
The court,
You would agree with me
Ms.
that
Robinson, hold on. Ms. Robinson, I got it. Okay? The inventory was in the divorce.
correct.
Okay? Which is not all that relevant to what we're doing here today. The failure to turn over guns pursuant to this court's order in the TPO, in the ex parte order, that is relevant. Okay? And I've got the answer to both. I've already heard it.
Yes, Your Honor.
Okay?
So you would agree with me that Mr. Hawkins is in contempt of the divorce documents, correct?
Yes, as well as in violation of the TPO. I would agree with both of those things.
So now I would like to talk to you just a little bit more in detail about.
Can we just laugh for a minute at the judge's face there? I want to go back 10 seconds. Just watch it without the
The
volume.
answer to both. I've already heard it.
Yes,
Oh,
Your Honor.
so he just told her, I already heard it. Don't say that again. And then she goes on and asks the question again. Face palm. Literal face palm. Oh my god.
Yes, as well as in violation of the TPO. I would agree with both of those things.
So now I would like to talk to you just a little bit more in detail about Mr. Hawkins' actions since you filed this TPO. Now, you would agree with me that since the filing of this TPO, you have communicated with Mr. Hawkins, correct?
Yes, until he was officially served, because the advice of counsel was to continue to act according to our parenting plan and information until he is served with the TPO. That it did not go into effect till he was officially served.
And on the date in which there was an affidavit of service entered, you also communicated with him via our Family Wizard app, correct?
Not after he was served. No, that's incorrect.
On the date he was served on January 26th, you did communicate with Mr. Hawkins via our Family Wizard, correct?
Not after he was served.
And you would agree with me that on February 1st.
Hold on a second. All right. Ma'am, I understood you to say that you did communicate with him the day of service through the Family Wizard app. Now, whether or not that was before, I don't know what time of day the service occurred, but did you not testify that you did communicate with him one time on the date of service?
Your Honor, I did communicate with him on the date of service prior to him being officially served. Once that happened, I did not communicate with him.
I was never informed of the time of the service, so I had no idea whether it was before or after.
It was approximately at 4 p.m. So I mean, communicate. Yes, sir. On the 26th.
Okay. All right. Go ahead, Ms. Robinson. Sorry to interrupt. I just wanted to clarify what I thought I understood from direct.
Yes, Your Honor. And you would agree with me that you also called Mr. Hawkins on February 1st, 2023, correct?
Yes, as I explained earlier, that was when I was taking screenshots of the photos of the calls he had made after he was officially served. And it was a misclick, and it was less than 1 second and did not connect. It was not an attempt to communicate with him. It was an attempt to document his communications with me post-service.
Yes. As we proceed, give me one moment. Okay, now I want to talk to you about you two's interactions from the time that you filed this TPO, and from the time the ex parte hearing was served. Now, you already have stated that you communicated with him as usual until you received word that he was served, correct?
Correct. Additionally, between the time I filed the petition, there was about a week before my ex parte hearing as well. So it was not granted until January 19th.
Yes, but during that time, you were communicating with Mr. Hawkins, correct?
Yes.
And during those communications, you talked about how to care for your minor son after he had his ear procedure.
Correct.
And you also agreed to meet with Mr. Hawkins at a park to do the custody exchange, correct?
Which date are you referring to?
On January 22nd, 2023.
Yes, that is correct, because he was going to be served by the process server at that time. However, he showed up at my front door hours before the meeting time.
However, Ms. Hawkins, I'm just talking to you about the exchange that you two had, that you were able to have an exchange on January 22nd of 2023, correct?
Yes, and I just explained the exchange, and also, my last name is Stewart, not Hawkins.
I do apologize. That is my apologies, Ms. Stewart. However, at no point in time during that custody exchange did Mr. Hawkins harm you.
He did not harm me. However, he did tell me he was aware the TPO had been filed and that it was going to harm him and cause lots of damages to myself and Harrison if I did not dismiss it.
However, he did not threaten your safety when he informed you of this, did he?
No, he had previously threatened to kill me on a different date. He did not engage that same words on that day.
I'm talking about this day in particular. And at no point in time during this exchange did you call the police.
I did not call the police. He had not been served with the order. They couldn't have done anything to help me at that point in time. Additionally, he has several friends who are on the Brookhaven police force. Therefore, I do not feel safe calling them because that has backfired before, where his friends have come and not listened to me because they're protecting a fellow officer.
However, I just want to be clear for the court's sake that there was no circumstances that led you to call the police against Mr. Hawkins on January 22nd, 2019.
Correct. I did not have, he was not served with the TPO. The police would not have been able to do anything for me at that point in time.
However, you didn't call the police to make a police report that he had threatened you, that he had harmed you in any way, correct? Because he had not.
Not on January 22nd.
And now I do want to talk about this threat that you keep mentioning. Now, you mentioned that Mr. Hawkins threatened to kill you on FaceTime, correct?
On FaceTime and then over the phone. It has been more than one occasion.
However, at no point in time, and I understand that you stated you do not record all of your conversations, but at no point in time do you have any record of him threatening your life.
No, I do not know how to record a FaceTime call. For our divorce decree, he gets a call with our son every night. So no, I do not know how to record a FaceTime call. That is beyond my knowledge of iPhones.
And Mr. Hawkins has never threatened to kill you in front of any other party or any other person, correct?
No.
And so no one would be able to support your allegation that Mr. Hawkins has threatened to kill you, correct?
No, we have not been together with a third party, since in a year, I would guess, with a third party present.
And the only instances in which you two interact relates to your son, correct? Physically, that you two physically see each other is in relation to your son, correct?
No, that's incorrect because Adam will show up at my front door to physically interact during times that are not his custody times with our son.
Now, I do want to talk about that front door. On direct examination, you stated that you have a security camera on your front door, correct?
I have a video doorbell, yes.
However, you also stated that you turned that camera off. Isn't that right, Ms. Stewart?
Yes, because Adam had access to my network. So I didn't feel that my video camera footage was safe with somebody whose job is reviewing and editing video surveillance footage.
However, you have no evidence of Mr. Hawkins hacking into this security system as you allege.
No, I only know he's read my texts and my emails, which for somebody who doesn't live in my house, I don't understand how else he's able to do that.
But you have no evidence of him hacking into your front doorbell camera, correct?
Correct. I have no direct evidence of that.
And you would also agree with me that this front doorbell camera is used for security measures.
Yes, it's a video doorbell camera.
And even though you claim that Mr. Hawkins shows up to your door and your house unannounced and that he's threatened to kill you, even when it is time for him to possibly come to your house, you do not have your camera on. Isn't that right?
That is incorrect. I disconnected the doorbell. I didn't say I disconnected the video portion of it.
However, on direct examination, you stated that you disconnected the doorbell camera so that you didn't have to know or see Mr. Hawkins on your front doorstep. Isn't that right?
Incorrect. I said I disconnected the doorbell. I did not specify the camera portion. And that way I am unaware if somebody is at my front door in real time. The doorbell does not ring. I do not know that somebody is standing on my front door. I I'm not actively monitoring the camera portion of the doorbell when I'm at home with our young child. I'm taking care of the child. So I disconnected the audio portion, not the video portion.
But you don't have any videos of Mr. Hawkins showing up to your residence unannounced.
I would have to search through the video history to find those. Again, there would not be audio, so I don't know the exact value of that evidence.
But you haven't presented any of that evidence, irrespective of how the court views that value, here today during your testimony.
I have not provided any videos. That is correct.
Okay, now just a few last questions, just so we can wrap things up here for the sake of efficiently. Now, during since your divorce has been finalized, you have never called the police in regards to safety concerns about your son while he is with Mr. Hawkins.
That is correct.
And you have never called the Department of Children and Family Services to try to indicate that your son is in danger while he is with Mr. Hawkins.
That is correct. I have not. I've done a lot of things out of respect for his job and because I do not want to ruin his life. I just want safety for myself and my son.
But at no point of time has any circumstances arose that would warrant you calling 911 because Mr. Hawkins has put your son in danger, correct?
I did call 911 when he didn't return my son and I had no idea where my son's whereabout was. I did feel that he could be in danger, and that's why I did call the police on January 13th.
But apart from that issue with the parenting time exchange, you have never called the police to state that Mr. Hawkins has harmed your son, correct?
No, I haven't. Again, he is friends with the police in our area. So the utility of calling the police is low, in my opinion.
Now, I also want to talk to you about the guns that you had brought up on direct examination. Now, that picture, I cannot remember the letter, but respondents,
E.
I apologize for the.
That's okay. E.
Okay. Yes, respondents E. If the court would be so kind to bring that up.
Petition or the respondent E?
Petition.
Petition, okay.
It has already been tendered into evidence. Now, just so we're clear, this picture was taken while you and Mr. Hawkins were married, correct?
No, I had filed for divorce at this point.
But you two were still
The divorce had not been granted, is that correct?
That's correct. The divorce had not been granted, Your Honor.
Okay. Then you're still married.
Unfortunately, yes.
And this picture was in the basement of the marital residence, correct?
That is correct.
And so this picture of this couch was not taken at Mr. Hawkins' current residence, correct?
Correct.
You've never been to Mr. Hawkins' current residence inside, correct?
Yes, I have.
And have you ever seen, and you have never seen a firearm in this capacity? You have no picture of a firearm loose in his current home, correct?
You are correct that I did not have a picture. The day I was there were firearms on the kitchen counter. So yes, there was a firearm loose. I did not document it with a picture. That is correct.
And you didn't present any of that evidence today during your testimony, correct?
I do not have a picture of it on his kitchen counter to present. But yes, the one time I've been there, inside the apartment, there were guns unsecured on the kitchen counter.
And you've only been to his residence one time, which means you have no idea of how many firearms are in his home currently, correct?
That is correct. I have no idea. Because he did not provide an affidavit of his guns.
And you have no idea of the way in which he safely manages his guns in his home, correct?
All I know is he's told me he keeps them in the closet. that is what I only know from his accounting of where they are. So no. And I also know that he did not move the gun safe to appropriately lock and secure them. So that's all the information I have about the guns.
And the gun safe is currently at your residence at this time?
Yes.
Now, and you know what? No further questions. Thank you so much, Ms. Stewart.
All right. Any redirect?
No, Your Honor.
All right. Any other witnesses for the petitioner?
No, Your Honor.
All right. Ms. Robinson?
Yes, at this time, if this court is so open, we would just move that the petitioner's petition for a protective order be dismissed as they have failed to meet their burden or provide substantial evidence to meet their burden of proof to prove that a family violence incident has taken place here, or that Ms. Stewart, is in fear of her harm or safety due to Mr. Hawkins' actions.
Ms. Shockley?
There has been multiple pieces of evidence submitted that would indicate that she is in fear of her life, that she has had her life threatened. She has articulated that she is afraid for her life, that there has been violence. I don't think that there's any space for a dismissal.
All right, Ms. Robinson, motion is denied. You may proceed.
Yes. At this time, the respondent would like to call Mr. Harry Hawkins.
All right, if you'll swear him in, please.
Please raise your right hand, Mr. Hawkins. Do you swear to tell the truth, nothing but the truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. Please state your full name for the court.
Yes, ma'am. It's Harry Adam Hawkins.
And were you previously married to Miss Courtney Stewart?
Yes.
How long were you two married?
2 years.
And before you were married, how long were you two together?
Approximately 5 years.
And at any point during your relationship with Miss Stewart, did you physically harm her?
No.
Did you ever threaten her with your gun?
No.
Did you ever hit her?
No.
Did you ever shove her with your infant son in her arms as she claimed?
No.
And have you ever threatened to kill Miss Stewart?
No.
Now, during your divorce case, did Miss Stewart ever mention that you threatened or harmed her?
No.
And has she ever taken a protective order against you in the past?
No.
Did she ever mention that she feared that you would harm your son during the divorce proceeding?
No.
And has anyone ever taken out a TPO against you in the past?
No.
Have you ever been convicted of any domestic violence charges?
No.
Have you ever been convicted of any violent crime?
No.
And do you have any type of criminal history or record?
No.
What do you do for a living, Mr. Hawkins?
I am a law enforcement officer for Georgia State University, and I work in the Department of Emergency Management. I oversee the drone program for the university and also a lot of the technology related to the police department.
And prior to this position in emergency management, were you ever in law enforcement?
Yes.
And how long?
I've been in law enforcement for 20 years.
And is handling a firearm part of your duties as someone in law enforcement?
Yes.
Are you aware of the risk that firearms have?
Yes.
And are you aware of the proper safety procedures in regards to handling and storing firearms?
Yes.
And when
I just got to jump in and say here, he's going to regret those answers and how he is trying to come across, I think. Because if you remember, the petitioner said that he hasn't followed the TPO requirements of turning in his weapons. So it should be interesting to see how that's handled. Just a little thing to look for.
you have parenting time with your son, do you ever have guns out accessible to his reach?
No.
Have you ever had any type of guns around your son for him to access?
No.
Have you ever left your son alone with your firearms?
No.
Now, I want to talk to you a little bit about the impact that this matter has on your job. Now, what impact would a protective order have on your employment as someone in law enforcement?
It would cause me to lose my Second Amendment right, the right to bear arms. And with that alone, I would not be able to be in law enforcement.
And has your employer expressed to you that you'd have consequences to your job should this order be granted?
Yes.
To the best of your knowledge, is Ms. Stewart aware of these consequences?
I believe, yes, she is.
I'm gonna have to object to the extent that this is calling for hearsay. There's no direct proof. The best evidence is not present. It's him saying that it's an issue is not exactly proof that it's an issue in my mind.
All right, Ms. Robinson, your response.
In regards to Mr. Hawkins or Ms. Stewart's knowledge of the implication that this has on Mr. Hawkins' employment, Ms. Stewart just testified on cross-examination that Mr. Hawkins made her aware of the implications this has on his job. And so therefore it is well within his reach, and something that has already been elicited from the testimony today.
Well, the previous question was more hearsay than this, but this question was based upon an alleged hearsay statement to your client who may or may not have related it to the petitioner, which you didn't cross-examine her regarding that, I don't believe. So I'm going to sustain the objection, and let's keep the hearsay out.
Yes, Your Honor. I'm slightly confused in regards to the hearsay part that's stricken. Was it the portion in regards to Ms. Stewart's knowledge, or what was informed to him by his employer? Because that was my last question, was Ms. Stewart's knowledge of the impacts that this would have on his employment.
You were asking him if she had knowledge of something that would have been based upon what his employer may or may not have told him.
Okay. Yes, Your Honor. So, Mr.
It's not hearsay for him to testify as to what he has allegedly told her. Now, whether he's done that or not, I don't know. You ask him if she had knowledge of it. That's all you ask.
Yes, Your Honor.
And the relevance of it, I don't make my decisions based upon the consequences. The chips fall where they may when we have a hearing and I issue an order.
Yes, Your Honor.
Okay, go ahead.
Now, Mr. Hawkins, what impact has this order had on your relationship with your son?
Well, since the TPO has been filed, as of today, I've missed 24 days with my son. I haven't been able to see him, and the last contact that I actually had on the day that I was supposed to pick him up on my parenting day, and Courtney didn't show up. That was a day that he was actually sick and had went to the doctor that day. And I was there to pick him up as well because he had been with childcare throughout the day, I guess, while she was at work. And that's why he wasn't at daycare, why I wasn't picking him up at daycare. And then that's when the incident happened, where a vehicle drives by my car while my vehicle's in motion and throws something at the side of my car. And on that day, I called Courtney to ask her, how much longer she was going to be, and I have not heard anything from her since that that day. So the last contact I had with Courtney in the parenting app in reference to my parenting time was that he was sick, and I've just reached out to her since then to just check on the welfare of Harrison, which is documented on the My Family Wizard.
And was this on January 26th of 2023?
I believe. Is that you talking about the last day that I saw Harrison, or are you talking about the day of the day of the custody exchange? Suppose my custody exchange.
Correct. The day in which your custody exchange was supposed to happen.
Correct.
You Ms. Stewart. Was this on January 26th?
Yes.
And would you recognize a copy of the messages exchanged between you two from our family wizard?
Yes.
At this time, Your Honor, the respondents would like for the court to bring up Respondents Exhibit 2.
I remember there's some personal information that she brings up. I'm gonna try and I don't know, regret or something. We'll see what I can manage.
Now, Mr. Hawkins, is this the correspondence between you and Ms. Stewart relating to that visitation on January 26, 2023?
Do we have the specific page number that would?
Yes, if you, I do apologize. If you would scroll down to page 13. Sorry, it's looking a little weird.
Okay, there's page 13. Is that the
Okay,
page?
yes.
Okay.
Yes, Your Honor. Mr. Hawkins, are these the messages that were exchanged between you and Ms. Stewart on January 26, 2023?
Yes.
Do they appear to be a fair and accurate copy of these messages?
Yes.
Have they appeared to be changed or altered in any way since the last time in which you saw them?
No.
At this point in time, Your Honor, we would request that Respondents Exhibit 2 be tendered into evidence.
Any objection, Ms. Shockley?
No objection. I shouldn't have on my mute. Sorry.
I saw your head nodding, but couldn't hear it. Okay, it's admitted without objection.
So just to be clear, on January 26th, you and Ms. Stewart agreed to meet at the park at 4 p.m.
Yes.
And at no point of time did Ms. Stewart inform you that she filed a protective order against you.
No.
And you can go ahead and take the messages down. Thank you. And at no point of time did Ms. Stewart tell you that she would have someone come along to the pickup location, correct?
Correct.
Has Ms. Stewart ever had a third party or law enforcement officer present during the custody exchanges?
No.
And and now I want to talk to you about the custody exchange on January 22nd, 2023. Now, when you exchanged your son after your visitation time, did you threaten Ms. Stewart at that time?
So the 22nd, that was Sunday. Okay, so no.
And at that time, were you aware that Ms. Stewart had filed a protective order against you? Had filed for a petition for a protective order against you?
On the 22nd?
Yes.
Yes. On the 22nd, I believe so. Let me see here. Actually, I don't remember the exact date that I was aware of it. So it might have been. I'm not sure the exact date.
and that's all right. However, at the last custody exchange,
Mhm.
did she make any indication to you that she felt at risk of her safety during that time?
No,
Did she call the police after you two's interactions?
no,
Has she ever called the police against you for harming her?
no,
Have you ever called the police against her for harming you?
yes.
And what happened during that incident?
So that was back after we had she had filed what was declared a false emergency hearing during our divorce. And at that time, the judge immediately entered in an
Relevant.
order.
So I heard a noise. I didn't know if somebody froze up or is everybody
Oh,
still
I'm
with us?
sorry. Objection, Your Honor, relevance. I'm not sure what the hearing in the, there's no evidence that, I mean, that's hearsay that there was a quote false emergency hearing. That's hearsay as well. And
Yes, Your Honor.
there's no court record of that is my point.
If I may proffer,
I'm sorry. Go ahead, Ms. Robinson. Your
if I may
response.
if I may proffer, we're just going to talk about the circumstances in regards to the physical altercation in which Ms. Stewart had
Okay, well, that was where I thought you were headed, but I don't need to know whether there was a court order, not a court order, whatever. Was there or was there not a confrontation? That's
Yes,
all
sir.
I need to hear.
Yes. And when this took place, did Ms. Stewart physically harm you?
Yes.
What did she do?
So she restricted my access into the home through the garage door. And as she was holding the door, she then opened it and then reached out and struck me with her hand. And I took a photo of where she hit me on my neck. And I think you have that in evidence. And then at that point, I contacted my lawyer about the incident and then immediately called the police.
And would you recognize the picture of the scratches and the injury on your neck if I were to show them to you in court today?
Yes.
At this time, may the court pull up what's been previously marked as Respondent's Exhibit 6? Now, Mr. Hawkins, is this a picture of the scratches in which Ms. Stewart left on your neck after that incident?
Yes.
Is this appeared to be a fair and accurate copy of the picture?
Yes.
Has it been changed or altered in any way since the last time you've seen it?
No.
At this point in time, Your Honor, we would request that Respondent's Exhibit 6 be tendered into evidence.
Ms. Shockley?
No objection, Your Honor.
All right, admitted without objection.
And so after Miss Stewart, physically harmed you on your neck and you called the police, did you try to harm her physically after that?
No.
Did you request that the police have her arrested as a result of her violent actions towards you?
Not directly. I just explained to them that, my understanding of the situation, being domestic violence, that when there is a primary aggressor, but I did not go into great extent. As a matter of fact, I did not even say that I was in law enforcement, and the times the police have been out to our home, I have never said I am in law enforcement whatsoever.
And to the best of your knowledge, has Miss Stewart ever filed a police report against you for your actions towards her?
Not to my knowledge.
So why do you believe that she filed this protective order against you if you have never threatened or harmed her?
That's a very great question. The only thing that I can conclude is there's a lot of this built up frustration from the divorce, from the settlement, And also, it clearly appears to me, and just over the past year, that it's literally it's restricting my parenting time, and that's been the most difficult part about this whole process, is because all I want to do is just, spend time with my son and be a dad, and I just feel like every time there's just something um, that she is able to do to restrict my parenting time, and this is just another example of that.
Okay. And just one last matter before we wrap up here. Now, even after this protective order was filed against you, and even after that incident with the process server, has Ms. Stewart ever tried to contact you?
The only thing that I've seen, just the missed calls. I had missed calls on my office phone, which I took a screenshot of, and also missed calls on my cell phone.
And would you recognize a photocopy of the screenshot of that missed call?
Yes.
At this time, we would like to request the court to show what's been previously marked as Respondent's Exhibit 4.
Okay, I think that this part is okay, but it's actually very interesting because this evidence isn't as good as she thinks. But let's not dox anybody if their info is up, okay?
Now, Mr. Hawkins, this is a screenshot of the missed call in which you received from Ms. Stewart, correct?
Correct.
Has it been changed or altered in any way?
No.
And does it appear to be a fair and accurate copy of the missed call and your call log?
Yes.
At this time, we would request that Respondent's Exhibit 4 be tendered into evidence.
Shockley.
I have an objection to the extent that I cannot see the date or any sort of,
Okay, so there's the time. Okay, here we go. I was going to ask that it be scrolled all the way down so we could see the whole thing.
Yes, but that is the full screenshot.
and could you let me know, let's see, all right, so this is
February 1st,
who
2000.
who is Francis Springer?
I'm talking about what's been the Courtney Stewart, not the Francis Springer. So if you would like to constructively redact that portion of the screenshot, we would have no objection to doing so as well.
How do I?
I don't know how it can be removed.
Yeah, I understand. That's why I said constructively, if so be. But we were just focused on the missed call from Ms. Stewart. And I also have another exhibit, if need be, with confirmation that that is her actual phone number and contact information, if this court would like me to provide that information as well.
Well, what my problem with it is I can't tell when that call came in. There's something down here that says Wednesday, February 1st, and it's an image, but that's not that call.
That's the day the screenshot.
Right. That's the day that he took the picture, because that's saying this is the day that like they always do when you've got a phone. But there's no way to see when that phone call that she allegedly made came in.
Yes, I have. If you look at the top, it has the timestamp in recents, 216 in recents, which states that is of the most recent call. And considering the time of the screenshot at 2:16 p.m., that is the last missed call that Mr. Hawkins received.
It is more important for the court to see an alleged call as to when it was actually made, not when the screenshot was taken.
Yes, Your Honor. And if I can have Mr. Hawkins testify as to what date this was.
Well, I'm going to sustain the objection as to this document.
Yes, Your Honor.
If you have something else, which I think you said you did, then I'll be happy to look at that.
Yes, I have. Yes, at this time, may the court please bring up Respondent's Exhibit 3. And this is the proof that's in connection with that. In regards to the confirmation that that is actually Miss Stewart's contact information, that was actually her calling, and it has the time in which that call was made on February 1st of 2023, and which is also the same
Actually,
conversation
that is a misrepresentation of,
that testified.
Hold on, both of you are talking at the same time here.
I'm gonna have to object. I see nothing, and we can scroll down, but I see nothing that indicates the date that this occurred.
That's critical. Is where does it show a date, Ms. Robinson?
Oh, I am
It says-
not
It
contesting that.
says
a date
Okay, it
Yes,
says
yes,
yesterday.
I'm
That's
not
all it
contesting-
says.
Yes, Your Honor, I'm not contesting that this document itself, that's why I did not tender this one into evidence to show that, because there's no date on this. The other document has a date on it, and I was just using this as support if the court wanted to see additional information. However, in regards to the specific date, it is only on Exhibit 4.
But that was the date of the screenshot, was it not?
Correct. The screenshot as well as the date in which the call was made or attempted to be made.
It doesn't show a date.
Okay, yes, Your Honor.
It showed a time, 2:16. And that was the time I understood that the screenshot was taken.
Yes, Your Honor.
Correct.
That is fine. We are able to proceed, and we are willing to proceed if this
Okay,
court
all right.
decides to sustain the
Thank you.
objection. Now, Mr. Hawkins, as you heard on Ms. Stewart's direct examination in her cross, she admitted that she called you.
Yes.
And did she call you after you had that interaction with the process server on January 26, 2023?
Yes.
Did you answer when she
No.
called you?
No.
Have you called her since you have been served with that protective order? Or when the affidavit of service was entered for that protective order?
No.
Have you tried to text her or reach out to her via text message?
No.
And have you had any contact with her, any conversations with her since you were alerted about the service of this protective order?
No.
And during that time, have you ever threatened to harm Ms. Stewart since the finding out of this order?
No.
At this time, Your Honor, no further questions.
Any cross-examination?
Yes, Your Honor. Okay, Mr. Hawkins, you stated that after being aware of service, that you did not attempt to contact Ms. Stewart by phone. Is that correct?
Not by phone. This only through the parenting app.
So
It
you
was-
acknowledge that you attempted to contact her through the parenting app.
The only
There is
what I'm saying is the only correspondence. No, after I received notification from your law firm that there was an act that I had been served. No.
Well, sir, were you not aware that you were served on January 26th?
No, ma'am.
You were not aware that you were served. You are a law enforcement officer.
I was not, ma'am. I was never giving any documents. Nothing was ever given to me.
Let's pretend for one moment that that was true. You testified a few moments ago that you were already aware of the TPO on the 22nd, and that would be because you were cyber stalking my client. Would that not be correct?
I said I wasn't aware of the exact date. The incident that occurred on the day that I was going to pick up Harrison on
Answer my question.
my custody exchange was a vehicle. I'm sorry, go ahead.
Just as I instructed Ms. Stewart, start out listening to the question, then answer yes or no, and then you may explain your answer, and she will not interrupt you while you're explaining.
Yes, Your Honor.
Your testimony just a few moments ago was that you were aware that there had been a TPO filed against you on January 22nd of 2023. That was before service was even perfected, but you testified that you already knew about it, and that is because you were cyber stalking my client. Is
Okay,
that
just one question at a time.
do you recall that testimony?
I said, I don't recall, I do not recall the exact date of of when I had knowledge of it.
Okay. But you had knowledge of it as of the 26th. Is that not correct? At a very minimum, you had knowledge of it on the 26th.
I have to look at my dates. I mean, just from recollection, I do not have the exact date.
You were served. I'll represent to the court. We'll be able to produce the affidavit if necessary.
Okay, so in reference to the service in which you're claiming that I was served, that incident is where I did not receive any documents. There's a vehicle that drives down the street and throws something at the side of my car, and I never received the documents.
Sir, that's not the answer. That's not the question. The question is, are you aware? Were you aware on the 26th of the TPO?
No, I was not aware of the. I was not aware.
Okay, hold on, sir. I'm going to ask you a question.
Okay.
If you weren't served, how did you know who the law firm was?
Because this was after the fact. This was after this incident. The law firm started emailing my job saying that I had been served, requesting my guns be turned over to my agency, and then they were saying that I had been served, and that was the time that I was aware that they're alleging that I was served, but I never received any documents, and it wasn't until later, like a few days.
Several hours ago, we proceeded with this hearing. Everybody was present, ready to proceed, and this is the first anyone has even mentioned that service was not perfected as required by law. Why are we hearing this several hours later?
She was asking me about my knowledge of being served, and I was explaining the incident of how it occurred. Like, I'd never actually received the documents. When the documents were sent by her law firm to my job, and I was contacted by my job in reference to this TPO. That was the date, and that's when I found out about it, was through my job, when they emailed they emailed the legal team at Georgia State and the director of my department, and then I was contacted by my boss.
Respectfully, Your Honor, I have the affidavit of service. There has been no objection filed to the affidavit of service. I'm happy.
We're proceeding as if service was valid.
Right.
We're several hours into this, so.
Right. I'm not. We weren't.
You can certainly present the affidavit, but you can do that in rebuttal.
Okay.
All right, if you want to present it now, you're on cross. Go ahead. Whatever.
Respect. I guess is it court? The court can take judicial notice, I suppose, since it's on the record. If you would like me to tender it, however, I will. And that would be plaintiff's F. Or not. Something happened with the way I have them numbered in a different way. I don't know what happened when they were sent over. Okay, it should be labeled affidavit. My apologies if the numbers got screwed up, but it should be.
It's Exhibit G.
Right, so they just got one off somehow in my things. Okay, all right. So I tender Exhibit G as a court record, an affidavit of service stating that Harry Adam Hawkins was served on the 22nd of January.
So I'm gonna take a moment here. I blanked out his address, but if we notice at the bottom, oh, his damn address is there too. Don't read here. I'm gonna read what it says on the bottom because I think he might actually have a point in a way. However, I think he's a liar. And so I'm not trying to help him anyway. But what it says in the additional comments, successful attempt January 26, 2023, 4:05 p.m. Eastern Standard Time at address in Atlanta, Georgia, received by Harry Adam Hawkins. Subject was parked in their vehicle at a park in a gray Dodge Charger. I parked next to the subject, opened my window to hand him summons. He drove off, left summons by his car as he drove off. I don't know if that is service, but they didn't dispute it to begin with. So the judge already said he's taking it as service. But let's continue on.
At 4:05 p.m., which is already part of the court record.
Okay. All right, let's move on. Any objection, Ms. Robinson?
No objection, as we have already proceeded and has already been introduced.
Okay.
All right. Okay. Could we take a look at plaintiff's H, please?
Are you sure?
I'm adding one, so I think I'm sure.
All right.
All right. Okay. All right. Mr. Hawkins, is that your phone number?
Yes.
Okay. Do you have any reason to believe that these are not accurate screenshots of times that you called your ex-wife?
Those are accurate.
Okay. So I'm going to.
Can we scroll down?
I'd like to tender Exhibit H as cell phone records or cell phone screenshots demonstrating contact to Ms. Stewart from Mr. Hawkins after having been served the process.
All right. Any objection, Ms. Robinson?
Not at this time, Your Honor.
All right, admitted without objection.
All right. I would now like to tender Exhibit I, or excuse me, I'd like to present Exhibit I for examination. Okay. Do you recognize this correspondence on the 13th of, I'm so sorry, could you scroll down just a little bit? Yeah. A little bit further. Okay. All right. Do you recognize this as correspondence between yourself and Ms. Stewart?
Yes.
Okay. And do you note that that you state that there has been no, well, I'll tender the exhibit.
Any objection, Ms. Robinson?
No objection, Your Honor.
All right, admitted without objection.
So you see at the very bottom there at 6:15, you say, I requested to see H on FaceTime and it's been 11 days and there's not a valid TPO. Do you see that?
Yes.
Did you write that?
Yes.
Okay. And why did you think there wasn't a valid TPO?
Like I stated before, because I have not been served with a TPO.
So you took it upon yourself to determine whether or not service was perfected, but you were obviously aware of it.
So I guess I need to clarify, like there's the TPO filing and being served. I think that's where it's getting confusing here. Like as Courtney,
there's no question pending.
All right. Well, just for my understanding of the chronology of events here. It's my understanding from testimony and from the record, it was filed on January 16th. It was heard by the ex parte judge on January 19th and granted on that date. But service, and we just saw the exhibit a minute ago. What was the date on the affidavit?
The 26th, Your Honor.
Okay. So this is from January 22nd, where there obviously has not been service, correct?
That is what it appears, Your Honor. And yet, somehow he knows about the TPO. That was
If I may, the timestamps on the 3 of those documents are different. The very top says Sunday the 22nd, Friday, and then 15. So I just want to be clear for the court that that last text message is not supposed to be indicated as being from January 22nd, but instead from another date and time in which
Good point. Well, each of the next 2, one says Friday, which I don't know which order this goes in, from bottom to top or top to bottom.
Your Honor, I will agree with Ms. Robinson that it is impossible to tell which day that text came in. However,
it's not impossible. This bothers me so much. If you know how iPhones work, it would be Sunday, January 22nd, the Friday following that Sunday. And then today, if they just scrolled up to the top of this image to see the date at the top, that would indicate the date of today. But they're not. She's not the most tech savvy lawyer, I guess. But anyways, listen on. We're gonna get to a real good smackdown here soon.
I can get the information from my client on rebuttal shortly to provide that, I believe. But also, it does acknowledge that he's aware of a TPO and he's still contacting her.
Yeah, I don't know whether it's a date after January 22nd or a date before January 22nd.
Correct. And I believe
I'm not going to admit the document.
Thank you, Your Honor.
Yes, Your Honor.
Mr. Hawkins, why do you believe that it is okay for you not to fulfill your obligations under court orders?
I don't understand. I don't understand the question. What?
Why have you not fulfilled your obligations under the divorce decree, which is a court order? You believe that you are above the law, correct?
No, ma'am.
Then why do you not obey court orders?
Can you give me an example of which court order you're referring to?
I can give you many examples. Why did you not relinquish your firearms when you were aware of the ex parte TPO?
I did.
No, you did not, sir. I challenge you to demonstrate to me, contact a law enforcement professional that can tell me that you did so.
Contact Georgia State University.
Okay, all right.
They took my firearm.
Sir, did your own counsel not state at the beginning of this hearing that you have alleged that they are not in your possession, but that you have not turned them over to law enforcement as required by the TPO?
I do not have any firearms in my possession, and the Georgia State University firearms, Georgia State University has.
Okay. What about the other 23 guns or 24? How many guns do you own, sir?
I don't own that many guns, and
how many do you say that you own?
I own 3 guns.
What happened to all the others that were in that picture?
I've given those to family members. Those are no longer. They are not at my apartment.
When did this occur, sir?
This occurred over a month ago. Well over a month ago.
Have you changed the registration to your family members' names? Did you sell these guns?
No, I did. They actually, some of them belonged to my dad anyway. So I gave them back to my dad because I don't I don't need to keep all those in my apartment. And the reason I don't have the gun safe is because the gun safe is way too big for my apartment. And so
Why did you agree in a negotiated settlement agreement to remove the gun safe and take it to your apartment and install it and keep the guns in the safe?
Objection, Your Honor, as to the relevance of this matter we're talking about.
Yeah, I'll sustain that objection in terms of why they negotiated something back in November or whenever versus what they actually did. My concern is where those guns are now.
Yes, Your Honor, that's our concern as well, and we've got no proof of where they are.
Your Honor, I do not have any guns in my possession. The guns that you saw pictures of, those are at my parents' house. Those are with my dad.
And that's supposed to satisfy the requirement under the law and under the court order that you turn them over to law enforcement instead of your parents.
No, that was actually done before. That was done a month ago. This was done well before the court order.
So why did you suddenly give them to your parents?
Because Courtney kept bringing it up to me about constantly saying that, you know, I'm in contempt because I haven't provided her the serial numbers for my guns. And so I realized that the best thing to do was to get rid of them and give them to my family and not keep them, because the agreement is that I had to provide her with the information of the guns that I had in my possession.
Okay, well, here, I'm going to ask a question.
Sure.
And I want a truthful answer, please. I understand the Georgia State gun is in the possession of Georgia State law enforcement.
Yes.
Which apparently you're the head of, or pretty close to it. Why was okay? What other guns have you purchased that are in your name? Tell me what they are. Tell me what kind of handguns and long guns you may possess or have in your name. Excuse me, not possess at this moment.
I have a Glock. I have two handguns. I have a Glock. I have a Glock. I have a 40. I have a 40 cal. They're two 40 caliber Glocks.
Okay. All right. What else?
That's it.
How long did you have possession of all of these other guns before you gave them back to your dad? Years?
Yes.
Why did you have them? Were they given to you as
Yeah.
a gift?
Yes. My dad. Because of some of them were my dad's, and before that they were in the family. And so when I talked to my parents about the situation, my dad agreed that I'd just give them back to him, and he would keep them at his house.
Where are your 240 caliber Glocks?
They're also right now. They're with my dad.
All right, go ahead.
Do you not also own some assault rifles, at least one?
Everything all the guns are with my father.
That's not the question.
Do you?
I asked you the question, and you said you only had the 240 caliber Glocks. Do you own a long gun? Do you own an assault rifle?
No, that's Georgia State's gun.
How many Georgia State guns did you at one point have possession of?
The gun that I'm referring to, the rifle was turned into Georgia State.
Okay, so it was a rifle. It was not a handgun.
Correct.
What did you wear around campus? One of the handguns?
So yes, when I was working in that capacity.
What do you mean in that capacity?
When I yeah, like I had a handgun when I was in a uniform.
Okay, are you required to wear a uniform?
No,
Okay, so then you're not required to own a gun, to possess a gun if you can wear a suit and tie to do your job, are you?
I maintain my certification, and
That's fine. You can maintain your certification. You're talking about your post certification.
that and also it gives me the ability to work extra jobs so I can make money.
Yeah, post certification, you just have to take your training hours every year, right?
To maintain,
Your post certification.
yes, correct.
It doesn't require you to hold a gun, does it? I mean, you go to classes for post certification, correct?
Yes, that's correct. But I cannot be a police officer if I can't carry a gun.
So you can't work your side jobs, is what you're telling me.
What I'm telling you is I can't work. If anything, if they could call me in, if they need, extra boots on the ground, for example, and tell me that they need me, in that capacity.
They who? Georgia State?
Yeah.
But you supervise all the officers, correct?
No. So I'm in emergency management. So the police department and emergency management work together, but the stuff that I do is more technology and drone related stuff.
Okay, so you do technology and you do emergency management.
Right.
Okay.
You don't
Do they require a weapon?
They don't require a weapon.
Okay. All right, let's move on.
believe you already, in an effort to save time, you did testify that you did contact Ms. Stewart via our family wizard on 126 and post 126, correct? We can pull up the exhibit again if we need to. In other words, after having been served with the TPO.
I did not have knowledge of being served until the service was emailed. The actual service was emailed from your law firm, and I have to pull up what that date was.
I have that email, and
Okay.
that date was the 27th. And so you still continued to contact her after that time, did you not?
So I did not. As soon as I had an affidavit of service, I did not contact Courtney.
So let me understand this. Papers were handed to you and you just drove away from them?
That's not at all what happened, and that's not what I stated earlier. I said I was driving. My vehicle was in motion, and a vehicle pulled up next to my vehicle and threw it at the side of my car while my vehicle was in motion. I never received it. My window was never rolled down. I don't know who the person was in the vehicle. I never received the documents.
Well, that's an inaccurate statement, obviously.
Okay, please don't argue with the witness.
Um,
Save it for argument.
That's all, Your Honor.
All right, any redirect, Ms. Robinson?
Very briefly, Your Honor. Mr. Hawkins,
Yes, ma'am.
have you ever stalked Ms. Stewart?
No.
Have you ever cyber stalked Ms. Stewart?
No.
Have you ever hacked into her email?
No.
Have you ever hacked into her text messages or iCloud protocols? I'm sorry, not technologically savvy, but
No.
her phone. Have you ever hacked into her security system at her home, including her doorbell camera?
No.
And do you have access to her personal communications on your own?
No.
No further questions, Your Honor.
Any recross?
No, Your Honor.
All right. All right. Any other evidence from respondent?
Not at this time, Your Honor. The respondent rests.
Okay. Well, this is the only time, so we need to say not at this time. All right. Closing arguments.
I'll reserve.
Oh, excuse me. I did not ask. Did you said something about rebuttal before?
No, Your Honor. I'm fine. I'll just reserve closing.
Okay. All right. Well, I meant as not as to the arguments. I meant you had said something an hour or more ago about presenting rebuttal evidence.
Oh, I don't believe that's necessary at this time. Your
Okay.
Honor.
I just wanted to give you that opportunity before we went to arguments. Since you said something earlier. Okay.
Good memory.
At my advanced age, I'm proud of it. All right.
Okay. I'm gonna make it number 3 its own video with the arguments and the judgment. So tune in.